Mine just turns itself off every now and then. Sometimes I give inspectors in the field.
No, mine's very low. Their Wi-Fi and all.
What's the other event for December?
Cartier Ready? John Chip. Wait, would you like to please Wait, are we streaming?
So I guess
Could we get a motion to return to the meeting?
Second.
Moved by Commissioner James, second by Commissioner Gonzalez to return from recess.
Yep.
All in favor, raise your hand. Any opposition? In exceptional case, the time limitations may be extended by the presiding officer with the approval of the board as information or review. If the case is deferred, it will be acted on at a subsequent meeting as provided by law. All proper parliamentary procedures shall be followed, including recognition of speakers, relevance of argument, and absolute prohibition of applause or demonstration. Standard of review. The Board of Zoning Adjustments has the power to hear and decide appeals where it is alleged there is an error in any order, requirement, decision, or determination made by an administrative officer in the enforcement of the comprehensive zoning ordinance. The board also has the power to hear and determine appeals from applicants who have been refused a building permit because of a violation of conflict with the zoning ordinance or the official map of the city. The applicant's appeal to the Board of Zoning Adjustments is governed by Section 5-408 of the City of New Orleans Home Rule Charter.
Thank you. We will begin with the unfinished business for appeals. Our next item is item number, and just as a reminder,
I was just about to say, just remind you of the
just
deferrals.
as a reminder, we took up 2 decision appeals earlier in the meeting. BZA 03019 for 4133 Bank Street and BZA 10419 for 601 Charter Street. These were both deferred to the December meeting. Our next item is item 15, BZA docket 02319 for property located at 1932 Joliet Street. This is an appeal of the decision of the Director of the Department of Safety and Permits as per Article 4, Section 4.8 of the Comprehensive Zoning Ordinance regarding the determination that the property has not retained legal nonconforming status as a bar.
Good afternoon, board members. For case 23-19, 1932 Joliet Street, on behalf of the applicant, we are going to request yet again another 60-day deferral. There was an issue with a state agency that unfortunately has pushed them to where we were extremely close. We just got hit up with a limited timing issue. So again, the department has no objection to that. The applicants aren't here if they communicated that wish to me. So hopefully this is the last time, as I know it continues to be a bureaucratic headache for the staff of the BZA to get this out. But I do strongly believe, based on what we've seen, we continue to see the appropriate steps being taken. There was just a little bit of scheduling snafu between the applicant and one of the state agencies that we're working with.
Just to be Stewart, is there anyone here supporting the applicant for docket number 023-19? Anyone here in opposition? Any questions from the board? Is there a motion?
Madam Chair, in reference to docket number 023-19, I move for a 60-day deferral at the request of the city and the applicant.
Second.
With regard to docket 023-19, it's been moved by Commissioner Malone, second by Commissioner James to defer the matter 60 days. All in favor, raise your hand. No opposition, the motion carries. Next item.
The next item was taken out of order. We will now begin the new business for appeals. Our next item is item number 17, BZA docket 102-19, for property located at 6437 Colbert Street, section 4.8 of the Comprehensive Zoning Ordinance, regarding the determination that building permit number 13-12200-ACCS, issued under the former Comprehensive Zoning Ordinance to permit a front-facing garage, has lapsed.
For case 6437 Colbert, 102-19, the applicant seeks to revive an almost 5-year-old permit in order to build a front-facing garage on the property. The city code clearly states that permits which have been abandoned for over 180 days expire. The permit becomes invalid unless the work authorized by the permit is commenced within 180 days after its issuance, or if the work authorized by the permit is suspended or abandoned after a period of 180 days after the time the work is commenced. That's New Orleans City Code. Because this permit was abandoned for longer than 180 days, it is expired and is no longer valid. The CZO does not permit front-facing garages in the SLRS 1 zone if the property has access to a rear alley. CZO Article 13.3.b states, in the SLRS 1 Lakeview Single Family Residential District, all single and two-family dwellings having rear alley access shall be prohibited from having front-facing garages, carports, and/or parking areas, and curb cuts in or to a front yard. The property located at 6437 Colbert Street does have access to a rear alley, and therefore is not permitted to construct a front-facing garage. Furthermore, this board, as a reminder, has already heard a request for a variance of this standard from this applicant. It was BZA docket 007-19, and the board denied this variance. The applicant may not use this form to appeal that denial. Given this, the applicant's appeal should be denied and the director's decision should be upheld.
I am a Lucy Card.
Right, need to pull the
I'm a Lucy Card, and I don't speak English good, and I don't understand when you talk offensive words. So I'm leaving Miss Williams and my daughter on commitment to speak.
So, good morning, or afternoon, Sharonda Williams, Fishman Hager, 201 St. Charles. As Mr. Smith indicated, this is a permit that was issued in 2013 for new construction that also included a garage. There was substantial work done in connection with the permit and work that was permitted. In connection with the construction that was done, there was a lawsuit that ended up being filed by Ms. Carr due to issues with the contractor, in addition to some licensing issues with the contractor that delayed the work. Nonetheless, there was substantial work that was performed. Mr. Smith cited provisions of the CZO, particularly 1.5F, regarding the 100-day time limit for getting substantial construction done pursuant to the permit. We believe that has been done. Substantial is not defined by the Pennsylvania zoning ordinance, and you all are vested with the discretion to determine what substantial work includes. And so, in this context, there was work done again on the primary residence with the addition of the laying of the foundation and the concrete slab for the garage. I would point the board to the St. Raymond versus City of New Orleans case, which talks about applicants getting a vested property right and permits that are issued by the city, and when they have incurred substantial expense in connection with the work that has been permitted. In this case, that is the case. You've seen this car. This is something that we believe you should exercise your authority to determine that there has been substantial work done, considering the fact that this is being put in to assist her in getting in and out of her residence.
she's got mobility and vision issues that, from an equity standpoint, we believe should allow you to grant this approval. And also in the actual response that Mr. Smith gave us in terms of the interpretation, I think that it was referenced in there that there was no precedent for allowing grandfathering in of this permit. And we believe that there are substantial instances where there have been this kind of front-facing garage grandfathered in under the law. So we believe there's adequate for that.
Yes, and also in reference, my mother didn't get her permit till March of 2016. She moved in the summer of 2016. With that said, we contacted just give you some update. The Contractors Board of Louisiana found many issues. They were the ones that suggested that we follow suit with our contractor based on what they saw was not done to the home, as far as finishing work and obviously the garage. And I contacted Zach Smith in 2017, so this isn't just 5 years old. We have tried to, within the year that my mother moved into her home, have been trying to ask for a grandfathering in of this when we didn't realize that the structure, once it was begun, would ever not be able to continue on. And with that said, we did contact and also had a meeting with the prior city planner, Chad Dyer, with Mr. Zach Smith, and myself, my mother, and Mr. Mantu. And in that meeting, Mr. Chad Dyer said, specifically, I see that this is no fault of yours, Lucy Carr, that this situation has grown to this problem. And which he encouraged and led us to believe that there would be a grandfathering in. But it then took several more months for Mr. Smith, and the reason that we couldn't do anything prior to that because we were still waiting for this decision that didn't come, I think, until July or August of this year. And so with that said, my mother has done everything the city has required. We also did not have all the information in our permit history of what was said or what was accused of my mother's property. And I just want to say, there are written documents that are not substantiated, and I would say actually not really the correct information that you may have received. Also in October of this year, I went to a zoning meeting with our community, and when I discovered that they did exist at a BCA meeting after a letter was read, I've gone to every meeting, and they said in October that when I explained to them that our plans had been permitted, stamped by the city, that it clearly showed that there were two access to the garage, front and back. They were not aware of that, and they said that they would not seek any type of negative or trying to explain the whole situation. And I just want you to know that not all the information you received was accurate information, because the zoning committee originally did not investigate everything that was accused. But we opened our home freely in March of this year, 3 years after my mother's occupancy, to the city, to allow them to see that the accusations made on my mother's property was not correct. And I know that this may not be specific to this, but it's a little bit of a history so that you know what we've gone through in the last 2 years trying to get this. It's not just today that we've asked for this, or this year.
Thank you. Anyone else here in support of the applicants for docket 102-19? Anyone here in opposition?
Good afternoon. Michael Tuso on behalf of the adjacent homeowner, Barbara Norman. My client would like to say that she agrees with the board's previous decision. In addition, she opposes this appeal as one, being untimely, and two, noting that they have raised no new additional facts that weren't raised before the board the last time, including raising the financial hardship issue that she tried to raise. The slab is down, that's it. The difference between the front-facing wall, which is allowed by the zoning, and the front-facing garage, which is not, would be minimal, probably cheaper to build a front wall than a garage door. One of the factors that the board determined last time didn't apply was the financial hardship. So I'm not sure why they're raising that again. This is approximately the fourth hearing that my client and other residents of the neighborhood have had to attend over this issue. Also, according to the training report that was pulled, apparently the permit for this garage was actually issued on 4/18/2013, to the best of my knowledge. So it wasn't issued in 16. She'd already moved in 15 or 16 and had been living there for multiple years before she even attempted to come get this variance. She also was approved to have, under a medical hardship, a front slab. She has undertaken no steps to have the front slab poured at all, the front parking pad. And what she's trying to do, and I stated this to the board the last time, she's trying to turn this into a McDonald's with a drive-through from the front to the back, which I'm not aware of any other residences that have that in the entire neighborhood. That's all we have. Thank you. Yes.
Just give your address for the record.
Sure. 2313 North Coleman Street, Metairie, Louisiana 7001.
Anyone else here in opposition? The applicant for docket 102-19.
Hello. Bruce Gebhardt, 6479 Colbert Street in New Orleans. So this house in general has been in violation of so many things from the very beginning. It's built without asking for variance. And then it's just like it's always better to beg forgiveness than it is to ask for permission. And so just in general, we're not used to having those front-facing garages, and it's code. Try everything they can do to get it, and I'm getting tired of coming to this thing.
So. Anyone else here in opposition to the applicant for docket 102-19?
My name is Deonta Leo. I live at 6464 Colbert Street, and I'm opposed to this because the front-facing garage means that they're gonna have a driveway from the street all the way to the back, even though they have access from the back. There's no need for that. It's not typical of Lakeview to have front-facing garages unless you don't have alley access, and they do have alley access. So I am totally opposed to this.
Anyone else here in opposition?
Yes, Barbara Norman, 6427 Colbert, and I'm here just to support the staff's recommendation that this variance be denied. And as a Lakeview citizen who tries to stay in compliance with the ordinances, that's all we're asking of our neighbors, is to be in compliance. Thank you for everything you do.
Anyone else here in opposition?
Owen Gordon, 6427 Colbert Street. We were here this year 4 times. This is the 4th time. On the same issue. Nothing has changed at all. We've been dealing with a long history of BZA board meetings dating back to, I believe it's March of 2013. This is nothing new. I know you have all the information and materials that I've been sending in that you can look at. And it's been kind of trying, to say the least. We try and stay in compliance. Now, I know I'm supposed to stay focused on the issue here, but just recently we were reported was a trailer in the back. Unbeknownst to me, in Lakeview, I did not know a trailer was not allowed. I immediately moved it, sold it, got rid of it. I was also reported about the air conditioning unit. I hired an air conditioning company. Air conditioning company did not file. I was reported. They had to go through all the routine on that. It was not my responsibility.
I am here because I want to stay compliant with all the issues and anything that I need to make for our neighborhood. I guess in ending, I'd say I'd like to be in agreement with the decision that was made in May after 2 previous meetings this year. We met in February. They were given a 30-day extension to come up with new material. We met in March. They were given a 60-day extension to come up with new material. They did not. We came back again in May. No new material. And this board unanimously denied the variance. So all I'd like to say is I respect y'all opinion, and I'd like to say that it was denied in May with no new material here. So I know it's left up to y'all, but all we just want to do as a Lakeview resident, just we need to stay compliant. And thank y'all.
Anyone else here in opposition to the applicant for docket 102-19?
Good afternoon, I'm Colleen Mooney from 6459 Colbert Street. I am in opposition. Originally, way back when it started, it was touted to be in this Carter's interest to build a house with a handicap access, and we were going there again, and none of the original plans had any handicap ramps or boards or anything like that that helped, or that was noted in the construction. We've been here 4 times, and it's been denied. And then the compliance issue came up, and they were given 2 more times to come in with new plans. They didn't do that, and now we're back trying to get your original decision overruled. Please support your original decision. Thank you.
Anyone else here in opposition?
Afternoon. Bill Coates, 6459 Colbert. We're here again. Like my wife said, it's the 4th time we've fought this issue. They're not in compliance. As I mentioned the first time we talked about this, we all came back post-Katrina. We were there pre-Katrina, post-Katrina. We all complied with the zoning codes the way they were supposed to. And I would like to have that code enforced, just like y'all did last time. They're out of compliance. They haven't given anything new that I've seen. They haven't talked about anything new. You know, the handicap issue, I'm not going to go there. But there was nothing in the plans that showed anything. So I'm strong opposition to this. Thank you.
Anyone else here in opposition? The applicant has an opportunity to rebut.
I want to thank y'all, and I hate to go off course again, but because these things were brought up. By law, my mother didn't get her completion until March of 2016, so the rules go by that, I believe. Secondly, the neighbor that says they're in compliance, they have 2 full garages. I've walked that neighborhood with friends for 3 months. They are the only people in the Lakeview area that have 2 complete garages. So that is, I do not believe in compliance. And I'm not here to say here and there they do. There were 2 people in our neighborhood that did renovations that are not in their permit, but they weren't reported. I feel that there is almost an attack on our family, on my mother specifically, and her property. We, in 2013, did everything the city said. Our house is a 1-family home called multi-generation that has different generations living there. These people have reported us nonstop about this, the same group of people, which today they have Lakeview properties, which they did not come forward and have any issues with those. Persons posted on electrical poles our property, but in these areas they did not. I just want to say, I see something here more, and I'm sorry that y'all have to be subjected to this, but you know, I am in total disagreement. In that 2013 meeting, it was proved by the zoning head that my mother did everything. And if people don't understand that there's different generations living in our home, the city inspected that also in March of this year. It is a 1-family home. We have no violations on our property, even though there were several flags put on that property because of hearsay. No violations when they entered our home by accusations. And I'd like Ms. Williams to talk, but I'm sorry I had to bring this up.
I just want to get back to the substance of the appeal. I know there's been a lot of discussion about a lot of other things. The substance of the appeal is the determination that this could not be grandfathered in under the permit that was issued in 2013. Again, this appeal is timely. I know there was some discussion about it not being timely. We received Mr. Smith's interpretation on this on July 30th, 2019. The appeal was certainly filed within the 30-day time frame. And the new issue before the board is whether this is something that can be grandfathered in. Again, I'll point you to the St. Raymond case that talks about vested rights and permits, and that is the reason why we're talking about finances at this point. It's not about a relit discussion about financial hardship, but those cases specifically say if you have put in a substantial amount of money or incurred a substantial number of expenses, then that should be considered in terms of whether a permit should be valid. And so for those reasons, we'd like the appeal to be granted.
Thank you. Questions from the board? Quick question to staff, because I'm just trying to understand how we got to this point. Because in the summary report that you provided, you began discussing the 180 days with work not being commenced. But there's also the discussion that these types of garages aren't allowed in the area. So I'm just trying to understand how the permit was granted if the this type of garage isn't actually allowed in the area.
So this permit was originally granted under the prior CCO.
Got it.
And, just to kind of clarify something in reference to 1.5.f, which is the CCO section, about, if you begin substantial construction within, you're allowed to continue. That absolutely is the law. What we have here is we have a situation where the certificate of completion was issued on the property. For multiple reasons which are not the city of New Orleans, the garage was not built at the time of the actual certificate of completion issue. So what we're being asked effectively here is to grandfather a slab that has been abandoned by a homeowner. So let's do a hypothetical, not related. Somebody shows on plans in 2020 to build a rear porch. And while they're doing their construction, they receive a permit for it. While they're building it, they decide they don't have the funds, they don't want to do it anymore, and they choose, with the building inspection division, they choose to get it CO. 20 years later, because that thing was on. So again, the grandfathering of the slab is not there. Again, if this thing had been open and continuous construction, there's obviously that citation would absolutely work. We advocate that on behalf of those all the time.
Make sure I'm clear.
The 180-day reference is that we set it. It's actually a building code section.
No, I'm saying what's the time frame that we're talking about? So when did the 180 days lapse?
The 180 days would have lapsed had construction continued. Your timeline ends when you get that certificate of occupancy, because you finished that construction. So one thing though that I did want to mention, and I'd ask if Emily was able to just discuss it. There was a couple points, and I think they were somewhat right and somewhat inaccurate about the accessibility. And I do believe that staff of the BZA, staff of the City Planning Commission, had heard and I believe even approved a reasonable accommodation request.
And I think it's been discussed previously, and just because of the nature of reasonable accommodations, a lot of that information wasn't fully disclosed. But I think that had come up in previous discussions about this property.
It is definitely our position, and we never like to see a permanent sunset on anybody. We work with folks, and I think the general public can actually argue with us on the opposite, that sometimes permits stay open because we take just about anything to keep them open, but when the certificate of occupancy, the certificate of completion is there, that permit life is done. And to say that we're going to go back, again from a prior CCO, it doesn't even matter if the CCO changes. Again, a new permit would be required, at which point it would be a new trigger to 159.
Quick question, please. Just to reiterate, what date was the certificate of occupancy issued?
I don't have that off the top of my head, but I believe it was in 2016.
2016.
I'm sorry, the documents that we have has March of 2016.
March of 2016, again, it's
I remember.
a bit longer than 180 days. Which is, again, certificate of completion doesn't even continue that timeline.
Yes.
Actually,
So to go back to the applicant, or Ms. Williams, either one, I guess the question, given the statements from the city, what I'm trying to denote from here is what do you have to sort of refute that there was substantial work done, or I guess
Still the CFO issue.
from that date? Yeah.
We tried to get our contractor to come back, do punch lists, which obviously the garage was a huge punch list. We had paid for work during the initial contract of the building of my mother's home. He then tried to deny that and doubled the price of it. And so when I said, well, we're going over all the books, all the records, and at that time, we never heard from him. So as we, for those months, tried to get in contact with him, to no avail, then we went to the State Board of Licensing for Contractors. And if you really know the history, it is no fault of my mother's. And in what they said, I gave Mr. Zach Smith, as well as Chad Dyer, nothing but a long list of front-facing garages. Colbert and Memphis Street being two of the worst offenders of that.
But that's not so. What I'm looking for right now is what work was actually done beyond March of 2016. Not just the. All of that may be one set of circumstances, but I need to hear. Even if you were having issues with the contract, and I there was someone else that came in to actually do the work. I'm trying to hear that there was actual work being done beyond that.
Well, we've been managing. We had security put into the slab. You know, it has been a long process because of the history of our building, not by my mother, but by accusations. There have been some contractors that wanted to pass because when they went to City Hall, they were kind of not wanting to deal with it. Or waiting for them to be able to give us estimates and things. And then, like I said, then attempting to get responses from the city or Zach Smith to have that meeting. You know, these were all delays, and it wasn't like a 1 month waiting. I think we waited 4 or 5 months to contact after speaking to Mr. Smith in December of 2017, and even going to the zoning committee to ask questions. That process, I don't think I was able to speak to a secretary till I think maybe May of 2018. So, and then once I did, but like I said, and if Mr. Smith would verify this, in that private meeting, given all the information that we brought, it is not my mother's fault that this has happened. It's only our naivety and our honesty to give people the opportunity. And we do feel victimized and attacked because other people in our community are not being treated the same.
So if I could jump in a little bit on this one. One thing I want to make sure that we're trying to, there's a clear delineation between two things that's following in parallel. When we talk about the certificate of occupancy, that says the permit has been filed, the work that was shown as the agreed upon contract. Let me finish, please. The completed set of contract documents that were submitted with that permit. Okay? And when you deem the owner in agreement with the contractor or whatever professional record may have been associated with the project, that you've accepted that the work has been completed in order for occupancy to be maintained. So once you get to that point, even if the garage was incomplete, my concern is that in order for the garage to have completed the work for the garage to be completed, an open wall inspection would still have to be done. I'm assuming an electrical inspection, and all of those are secondary inspections that would come from safety and permits or one of the persons on staff in order to help to close that permit. So when a CFO is issued to a package, even if a part of the scope is closed, that's acknowledgement that the work is completed as it runs parallel. Now, as it falls with regard to the contractor who was building the home, there's a separate contractual agreement that you as an owner may deem necessary to say, okay, hey, we're running once again parallel path. Open contract, you have to have that contract
signed with the dollar value disclosed for the permit to be issued. When that contract runs parallel and you get towards the completion of that work, you could then deem some small an accessory structure being considered a punch list item on a then closed permit. How would you be able to move forward at that point in order to come back and request open wall inspection, closed wall inspection, electrical, mechanical, anything that may be tied to that scope of work if the permit is closed?
I wanted to tell you the contractor did not get the completion documents. We were told in January my mother was being put out of her rental apartment. She had already sold her property because we were promised in 2012 that it would take 1 year to build. Obviously, it did not. My mother paid cash for her home. In January of 2016, the contractor stated that she could move in. She really didn't have a place. She was living from one sister to another in a non-multi-generational home. And so, with that said, I went to the city. The city said that we still had 2 completion documents that need to be done before she got completion. We got that opened. It was in March when someone had denied us in the permit office, and the director at that time came out, saw us. However, you are accurate telling our employee that you did go up for those items. So we had to file. We had no idea when we were, as the inspector had said. The contractor was not there and did not get the completion. So with us as no idea that a building permit would lapse on a structure, we knew that we'd have to get more electrical or something, like, individual, especially if we went to another contractor. But we had no idea but my mother and I got that at the office by the director at that time, when we were being told by someone in that office that we were not going to ever get it anytime in the future. But he came out, saw us, and gave it to us. So there is part of it. The contractor never got our completion.
Just from a safety and permits process standpoint, who else needs to sign as a party to the CFO, if any, beyond the owner?
As is pretty much everything with our Chapter 6 and our Chapter 26, the owner of the property is responsible to have the appropriate people on the job. If the department was intertwined in every contractual relationship between parties, whether that would extend this property more than 180 days, let that one close, etc., etc., etc. I mean, again, we would have to have 40 more additional staff to monitor contract.
Oh yeah, and I'm not done. Okay, yeah. So what I want to make sure I'm stating is the question is, I know that within commercial projects, if we're talking about something, say fire marshal, architect of record has to file for it, or some other parties are party to a CFO being issued. So I just wanted to touch base just to check to see does that reign true here with this scope of work? It's just the onus of the owner.
The way that you would have it, as a commercial property, would have some sort of documentation from the fire marshal, and there's been this approval from the professional record for those properties that have oversight from the professional record. Yeah, we don't have those. We have properties that do have contractors. We have properties where the home builder is allowed is the property. And again, if there was an issue with different errors with CFOs, and those things have been appealed to your office all the time. You usually hear that pretty quickly from the applicant, and usually people don't take occupancy for almost 3 years. So again, for us to come back 3 years, have an appeal, or have a variance request that's denied, and then take an email and try to turn that into the grandfathering slab, again, it's pretty clear what the answer is. But again, if the answer somehow is not what I would hope it would be, then I need to go back down to the council and ask for more money to sit here and better manage every project and see what state their contractual relationships are. It's going to be impossible. And it's not something I think anybody in the public wants the government to do.
So another question for you, just kind of understanding process in the 180-day windows that you apply. That same application, because you made mention about there's projects where a permit has been applied for and it's still an open permit and it goes on for an extended period of time. There has to also be some form of formal communication between the department and the applicant as well within that 180 days in order for it to be extended.
Specific to specific to extensions of a permit, open permit, not a closed permit, absolutely. And again, that's something that the department handles regularly, where you have the developers who start to pull a permit and the financing gets thrown to the side. So rather than go just close this out in 6 months and go, there's an ongoing conversation, or you want to go even quicker and the total review takes longer. Again, financing is usually something that delays that. We go to a permit issue where the projects, and some projects take 2 days, some projects take 2 decades. And the department does not shut those down. That's actually specifically the provision of 157. When you get started, you continue as long as you continue. But once you close, a new is required. And again, we're talking about multiple attempts at the same thing that have all been unsuccessful. And I generally find that we try to weigh these and measure these. And there's absolutely extenuating circumstances with some hardships related to the applicant. But again, the hardships, as far as I'm concerned, are for variance requests and not for these appeals. Those are technical in nature and should be based on the technical merits.
Right. So I think one last point, and this is just more to the neighbors and some of the people that did speak against this appeal, as opposed to zoning waiver of variance request. So we're not talking about the merits no longer of that 9-point criteria where we're talking about financial hardship. All of that is actually out of the window in this conversation. So I just want to make sure you all are clear, because I think that was a large part of you guys' dialogue. I didn't want that to go unheard or unanswered. So I think it's really important to understand we're just literally talking about the interpretive nature of what the department has stated, and is there an error based on that in our understanding and comprehension of what the CTO states?
And that this is a separate decision from that variance decision. I don't want you to think, for both the applicant as well as the audience, that these are two separate instances. It's difficult when you're dealing with the same property, but just to make it clear that this would be a separate decision, separate from the variance decision from previous. Any other questions from the board? Is there a motion? Thank you for clarifying. I know sometimes I get in the weeds with some of my questions, but I was just trying to understand kind of the process from beginning to end. So thank you for that.
You're always welcome.
So, one person's perspective, I'm not speaking as the board. The problem that I'm seeing is that, unfortunately, when we go through the process, there are triggers that do occur throughout the permitting system. And I think that what we're dealing with right now is there is the one caveat that once a certificate of occupancy is issued, a permit does fall closed. Now, if that, and I understand what you're dealing with the hardship and I'm saying hardship not for non-criteria language, the hardship of trying to get into the property. Okay, so a challenge, I'll say that so we don't get caught up on language. In order for that to happen, would they have been able to move in with a TCO? Question is that?
Yes.
Okay. So there are other administrative elements that happen through the permitting process. It's not just a rush to get into a certificate of occupancy for someone to move in. The TCO would have been the appropriate venue to go through at that time, even though the garage wasn't complete. And the TCO could have been held open for any extended period of time, especially when litigation is pending with the individual contractor. Is that, I'm saying something, but I'm looking for confirmation either from staff or legal.
Yeah. We have all sorts of properties that you take partial occupancy of something. If there's something that's a major issue that's not life safety related or not holding up all parts of it. Hotel 10 stories, you might give occupancy to 5 stories while you continue work on the 2nd through 4th, and you keep the lobby open and the life safety stuff open.
And there's no expiration date on TCOs unless it's requested in the beginning.
We specify what their period is good for, and the same sort of thing. They do have. I mean, it's the real world where there's real life dates and there's real life things. Because again, if not, then you get a permit today and you have it for life. And that's clearly not what happens. It's clearly not practical, and it's kind of weird to think about that. But effectively, that's what this request came down. I did something half a decade ago. I chose not to pursue it for whatever reason. Definitely not a city relationship issue, and now we just want to pull it back up, especially now that laws changed. Now I want to grandfather it under the old thing.
Okay. So the reason why I'm bringing up all of this, and I have to respect, we have to look at it in terms of what the letter of the law states, but also clarity and understanding what the process is at this point in time. So I think it's the fortunate but unfortunate part of once the certificate of occupancy is there and it's closed out and there's no ability to come back to do any further inspections on site for future work without a new permit being issued, it's hard to really get to a point of saying, okay, yeah, the potential non-conforming use remains, especially if the permit is closed. Because the second, if you were to come back to try to expand that space or to do further improvement, a new permit would have had to be issued, and there's no way to grandfather it back to the previous CZO. So I think that's where we are right now at this point. I think it makes it fairly clear, at least from my standpoint. And I'm sorry, I'm not asking any more questions. I gotta give dialogue to what I'm gonna present as a motion. So that's where I'm at this point. Where at least from my standpoint, it seems pretty clear because there's an established process. I'll say this: is there an opportunity down the road that if there's a way for that to be further explained to applicants of when you're requesting a CLO, understand what you're asking for when you establish for that CLO? My request would be, sorry, because of course this computer closes up on every time. With regards to docket number 102-19, my motion would be to uphold the decision of the Director of Safety and Permits based on a lot of the dialogue that's provided, understanding the known process of what happens for an open permit, and when a permit is closed, and at the completion of that permit, that's when the 180-day clock would have actually it wouldn't even start at that point. It's done because the project is then closed out. Second.
With regard to docket 102-19, it's been moved by Commissioner James, second by Commissioner Gonzalez, to uphold the decision of the Director of the Department of Safety and Permits, finding that there is no error in that decision. All in favor, raise your hand. Any oppositions? None. The motion carries. Next item. Last item.
I have to find out who put my name in it.
Our next item is item number 18, BZA docket 10319, for a property located at 3100 Bank Street. This is an appeal of the decision of the Director of the Department of Safety and Permits. As per Article 4, Section 4.8 of the Comprehensive Zoning Ordinance, regarding the determination that the mixed-use development exceeds the maximum allowable building height based on the interpretation of primary facade.
Hey, y'all doing? I'm Jared Bowers with Albert Architecture. We're 322.
Sorry, we need the specifications first. Sorry.
He's trying to go find icy.
You get an icy, you have to give.
You get bring everything.
Yeah. Including our guests.
Super smooth. Oh, moving on. For 3100 Banks, docket 103-19. The department initially approved this project, but upon subsequent review determined that the structure did not meet the height requirements of the district. The HU-NU district only permits structures which are a maximum of 40 feet tall and no more than 3 stories in height. Article 26 of the CZO states, where maximum building height standards include both the maximum height measured in feet as well as the maximum number of stories allowed. The maximum number of stories allowed shall only apply to the primary facades and shall allow for an additional floor behind the vestibule for parking, mechanical, and service uses. Primary facade is defined by the CZO as the building faces that directly face the street frontage or public right of way. It's clear from the CZO's use of the parenthetical as that there may be multiple primary facades. The plan shall a structure comprise 3 stories on the Bank Street facade and 4 stories on the South Salcedo Street facade. The South Salcedo facade includes a lobby level at grade with 3 residential levels above this lobby and faces directly onto the South Salcedo Street frontage. 4 stories are not permitted on a facade facing street frontage, and therefore the plans as proposed do not meet the height requirements set forth in the CZO. Applicant argues that physical constraints necessitate a rear raised parking area, and that the only part of the structure at grade on the south Salcedo facade is a fire rate egress door. The presence of the door is indicative of a floor at that level, and the arguments pertaining to physical constraints of the property are more properly presented as part of an application for a variance. Furthermore, applicant contends that there may be only one primary facade, which in this case would be the Bank Street facade. For the reasons discussed above, the department disagrees and feels that the CZO is clear in its contemplation of multiple primary facades. Applicant also asserts that the prior improper issuance of permit creates a hardship and fails to provide any details regarding the nature of the hardship. Because the property faces onto both Salcedo and Bank Street, it has multiple primary facades under the CZO, and the 4-story facade on the South Salcedo Street face does not meet applicable zoning laws.
You can give your name and address first.
Jared Bowers with Albert Architecture for 32212 Lane.
Melissa Style with New Orleans Redevelopment Fund, 322-1299.
So, I guess at a really high level, it looks like the zoning code as written kind of has an internal conflict with how that resolves itself through elevated buildings in the city. If you all have our letter in front of you, we show the CZO figure 26.4a and how to kind of calculate split level buildings. And you can see our building section is virtually identical to that. Because we have a raised floor and a split level, you still have to get into the building from a public right of way. So the building still needs to touch grade, and people still need to be able to get up into it. We had originally designed the exit from that stairwell to open into the parking area, but the fire marshal had us move it to the location it's in now. Due to this diagram, I think one could use law in the spirit of the CZO, just by virtue of how the building is configured. We feel that we've designed the building to the letter as well as the spirit of the CZO. It didn't seem that there was any sort of reference to this diagram, but having an asterisk or saying that this would be adjusted based on the project's location on the lot frontage. I think we also feel that considering the Salcedo facade as a primary facade is incorrect. Salcedo is immediately evident as a secondary or tertiary feeder street into Bank Street, which is obviously the primary street in that intersection. So the extension of that understanding would make sense to have the primary facade of the building along Bank Street and the secondary or tertiary facade facing Salcedo. Let's see. Yeah, I mean, I assume you all have already read the letter, and that kind of lays out our primary positions. I just want to reiterate a couple more of those things. As well as to point out that it didn't seem to be an issue when the project was under consideration for permit review and we received the permit and are now under construction.
Anyone else here in support of the applicant for docket 103-19? Anyone here in opposition? Any questions from the board?
Is that just an excerpt from the code, or does that have our letter that shows our section next to it?
That's the code, but we have all of the information in our packets.
So to be clear, in plain English, we're just making a determination on whether or not you're correct that this particular building has 2 primary facades, correct?
It boils down to that. There's really at the heart of it is a definition.
Sure.
And it's does primary facade incorporate, multiple faces, which has that parenthetic glass. And this was a really rough one because, as you can see from the diagram, the diagram has some words before it that say, this isn't indicative of every situation, but it's a question of, does the parenthetical glass refer to every, of the 4 points of a typical square-sided building? Does it refer to those? If there was an L-shaped building and there were 2 parts of that L at different depths and setbacks from a front line, is that what it refers to? And we had the option. We felt we went with the more correct. I could definitely see where there's a situation where that parenthetical S refers to multiple planes all facing one side, because to some degree you could argue that there's additional steps required for a corner lot that other properties wouldn't have this issue with. So the same building design, same building that is pretty much designed on any lot that's not a corner, we know would be 1,000% correct. So it kind of comes down to the reading of the term primary facade. And in this situation, we have to go with the most restrictive. But there is a conflict in the definition. It says primary facade, and then there's a reference to that parenthetical S, which implies more than one. So it gets a little tricky, and this would be the first definition of Bench Street that's really taken some time to get to the bottom of. But this is one of those ones that at the end of the day could literally go either way, and it's pretty much right there. This is the first case that we've seen where it's presented a situation. And some of that's as we continue to do more of these neighborhood type projects, as we get further and further away from the 2015 CZO change. So this probably won't be the last, and it would be good to have some clear guidance on what that definition is. But again, to me, the real root of this is primary facade. Primary facade really refers to one and one only, and that means that their corner condition would be appropriate, at which point we would rescind, we would change this opinion and move on a different route. If primary facade clearly covers multiple sides, which we know always isn't the case. If you had a 4-sided building in the entire city square, you're never going to get that. So there's clearly something to be said about the diagram. We just weren't 100% on it. We went with our a little conservative and a little bit more restrictive because of the conflict. But again, if primary means one, then we know the parenthetical S must mean multiple planes on that same side. If it means just multiple sides, then it's a whole different thing.
So what would you take into account? I know that when we're talking about how lots are described, there is what is the front yard versus side yard conditions. Does that help to support maybe more of what they're trying to achieve, where more often than not we're trying to get that front facing treatment to one part of the building, and we can give it the respect of what would be considered the front yard.
So this is where there's yet kind of another conflict in my opinion. The narrow side is typically the front. The narrow side would be the Salcedo side.
Right.
But when we get into design standards as part of design reviews, and this project has had a very, very, dare I say, unhealthy history between commissions, and boards, and waivers, and whatnot. There's been a huge amount of planning and a huge amount of standards that have actually pushed the primary entrance, the primary architecture onto banks. So that's what, even coupled with that history on top of this, has got us in a real quagmire because personally, I see an issue with it, but again, I can't overlook the fact that we have faces, the word faces with that parenthetical S, which again implies foot. So again, there could be a very reasonable explanation of how faces actually applies to only one side.
So back to that
point. Part of it just isn't there.
Right, so even back to that point when we get into design standards and design review standards, in this case, because of some of the language that's within CZO, and particularly when we're talking about multimodal corridors or primary thoroughfares, that's what drives this conversation more along the lines of the primary facade in this condition being Bank Street as opposed to Salcedo, right? So once again, I get exactly where you're coming from. It's just you're dealing with the broad definition of what's shown within the document, but we need to at least help to drive the conversation to what is the more appropriate venue in order to come to some point of resolution. Okay?
And that is certainly an option of the board.
Okay.
To be strictly picky about that, if you've got that S. That S on face, because face is used as a noun and a verb in the same sentence. So we have to have parenthetical S on the verb as well as the noun. That's a picky distinction.
See what happens when you have an English teacher on that?
Yeah. See, the building faces, that's a noun, so it can be either singular or plural.
Right,
And if
but
you
the
get to
verb
the
is-
face when it's the verb, it has to be in verb noun agreement, verb subject agreement, so you have to have a parenthetical S on that as well.
From a grammatical perspective, I would
Yes, this is strictly grammar.
Going to grammar. The point being though is that you could have, let's say you have an L-shaped construction or an L-shaped.
I know what it is.
with the street, where you could have two frontages.
Two different addresses on two different streets.
Well, two different planes of a building, all parallel to the same street, all facing the same street. So it's still completely, if that was a possibility, then again, two separate, plural, but still identifying just that one primary side.
Primary means one.
And yet the definition has an S.
Right.
So
That's grammatically incorrect.
that's why we're here today.
Many laws that are written are definitely grammatically incorrect. I can say that, but I think that's what I was talking. But I think that's what I'm having a problem with is when we look at what our responsibility is as the board in determining whether or not the department made an error in their decision is what I'm hung up on. I'm listening to the process and everything that you've done to come to the decision, and so then the onus is on us to say, was that an error? Right. Whether or not we agree or disagree with the determination, the question is, was there an error in what the decision you made? And I think that's what I'm getting hung up on, because I may not agree with grammatically, as Commissioner Malone said, it may not be correct. But the question is, was that decision correct? Was that process accurate?
Made more difficult by the difficulty.
So I'll go a step further. Kind of coming back to the point you just made a minute ago, talking about an irregular shaped building, where it may be L-shaped or some other form of geometry, where multiple faces of that building face that one right of way. That could also be inherently what we're addressing, because you basically speaking to that point. Yes, we may have multiple faces that go to multiple rights of way, but at the end of the day, we could be dealing with theoretically more than one plane, because it does say face. I'm actually step back and look at when I'm seeing is faces, which I'm taking as multiple planes in parallel facing one right of way. Plus, it just says face, which I'm thinking in order for you to come up with that primary entrance.
I think in the example of the regularly shaped building with multiple planes, it's a lot cleaner cut. I think absolutely apply that as the primary facade. This does present a little bit more of a challenge.
So I'm thinking more along the lines of intentionality of when it was drafted. So once again, that may be the case where you could easily have a structure and where a courtyard could have easily been in front of that secondary facade. So it met those multiple facades still facing that primary face, but it does not face multiple. They're not talking about the facing of multiple property lines or multiple faces towards multiple rights of way or outward facing portions of the building.
That's definitely a possibility.
And I'm actually, that's how I'm interpreting this, just based off of how to get this a little bit more clean. Madam Chair.
Are there any other questions? All right, we had enough geometry, English, all the classes. Is there a
So
motion?
multiple faces of architecture.
Right. Is there a motion?
Yes, Madam Chair, for motions in order. My motion for, document number 103-19 would actually be to overturn a decision of the Director of Safety and Permits, where while I understand the intentionality of how they may have interpreted this language, my belief is that when we're talking about the multiple faces, we're talking about multiple planes on a singular, that face a singular part of the site in order to help to address what is actually considered to be the building frontage. So in that case, I think that the decision should be overturned in favor of the applicant.
Second.
With regard to docket 103-19, it's been moved by Commissioner James, second by Commissioner Gonzalez, to overturn the decision of the Director of the Department of Safety and Permits, finding that there was an error in that decision. All in favor, raise your hand. Any opposed? The motion carries. Any other items?
Move for adjournment.
Just before we do that, the next item on the agenda was taken out of order earlier and deferred to the December meeting.
We've already
We have already heard, yes, item F. So is there a motion to adjourn?
Sounds like there is.
So
Been moved by Commissioner Gonzalez, second by Commissioner Malone to adjourn our meeting. All in favor, raise your hand. No opposition.